reservation on economic basis does not violate the basic structure of the Constitution. A 5-judge Constitution bench led by Chief Justice of India UU Lalit observed this on Monday while nixing a bunch of petitions challenging the 103rd Amendment to the Constitution. The amendment provided a 10% reservation to people of economically weaker sections in central government jobs and educational institutions. But the EWS category excluded those from the SC, ST, and OBC categories. The petitioners, while challenging the amendment, had claimed that the grant of 10% reservation to EWS violated the 50% ceiling cap on quota. They also sought a decision on whether economic backwardness alone could be the sole criterion for granting quota in government jobs and educational institutions for those who were under the general quota. But the judgment wasn't unanimous. CJI Lalit and Justice Ravindra Bhatt dissented with the majority view. The other 3 judges were Justices Dinesh Maheshwari, Bella M. Trivedi, and J.B. Pardiwala. Justice Maheshwari said that reservations were an affirmative action measure not only for socially and economically backward classes but also for any disadvantaged section. Therefore, reservation solely on an economic basis did not violate the Constitution. Second, the exclusion of scheduled castes, scheduled tribes, and other backward classes from EWS reservations was constitutionally valid. Meanwhile, voicing the dissent, Justice Bhatt said the amendment struck at the heart of the Equality Code and was discriminatory and violative of the basic structure of the Constitution. Ashwini Deshpande, a professor of economics at the Ashoka University, said the verdict reinforced the point that this was a quota for the upper castes, even though it was presented as a move away from caste-based quotas. Noting that the income ceiling had not been touched, Deshpande said that any change in it would have opened up a whole new controversy, as India did not have very reliable income figures. The professor believes that the current ceiling is not a good measure of the genuinely poor population, as most Indians fall below this cutoff. According to her, poverty is a transient state and should be addressed through vigorous anti-poverty programs. Shankar Raghuraman, a senior editor with the National Daily, had previously written that if the EWS quota was 10%, the line that separated the poor from the rest should have been determined in such a manner that it covered only the poorest 10% of the population. Instead, a family that was at the EWS quota's income threshold of 8 lakh rupees in gross income annually would actually be within the top 10%. In January, the government had told the Supreme Court that the annual family income of 8 lakh rupees was a reasonable threshold to determine EWS. It said that the income criterion for EWS was more stringent than the one for the OBC creamy layer because, despite being the same cutoff number, their composition was different. On Monday, Justice Bhatt said that allowing a breach of the 50% cap set on reservation could lead to further infractions, which could result in compartmentalization. For their part, the 3 judges who gave the majority verdict noted that the EWS quota did not breach the ceiling limit of 50% placed by the Indira Sawhney judgment on reservations.
It may be that they have restricted what has been said in Indira Sawhney to reservations for the constitutional vertical reservations for SC, ST, and OBC alone. That alone is treated as reservations. This EWS quota may have been treated as apportionment of the unreserved category. Short of that, I don't see how they say that the 50% quota is not breached.
Analyzing the verdict, Supreme Court senior advocate Sanjay Hegde said the case dealt with a complex definitional problem. According to him, following the verdict, there will be great competition among the forward castes to be declared economically backward. Hegde foresees a much more fragmented society following this judgment. He reasons that as they compete with each other, the heartburn that existed among the forward castes towards the reserved categories will now also become visible within the former category itself.
When further questions arise, supposing one set of unreserved candidates wants to challenge another set of unreserved candidates who have got the benefit of EWS and say, no, the fellow actually has 8 lakhs, more than 8 lakhs income. His family has more than 8 lakhs income a year. You must include salary, which he gets from the government. You must include his agricultural income and all those things. So somewhere or the other, those issues will work their way back to the Supreme Court. And it may well be that at some stage, the Supreme Court may be compelled to relook the judgment. But for the moment, for the immediate conceivable future, I do think the judgment will hold and continue to operate. Will it iron out the creases or will it lead to further confusion? I frankly think it would lead to further confusion.
Now that the verdict is out, the government will have to carefully track the second order effects that follow, given how sensitive the topic of reservations is in India and the far-reaching social and economic consequences it can have, especially for the most marginalized among us.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.